Slip and fall cases or trip and fall cases present really a complicated set of laws in Virginia. When someone is injured, when they slip on something in a store, the first step that has to be taken is the person has to establish what's called primary negligence on the part of the store owner or operator. What does that mean? It means that, well, you have to establish that the store did something wrong in layman's terms. And so if I have slipped on a liquid on the floor, what did the store do wrong? I have to establish a couple of things. Either that the store created this condition and was just callous and was, had no concern for the public, or I would have to establish that the store knew of this situation and didn't take any steps to protect the public. And in that sense, you have to establish that the store did something wrong, primary negligence. The store, on the other hand, is able to use some legal concepts to defend themselves, and generally that comes under the heading of contributory negligence. In Virginia, if you are partially at fault for your injury, Virginia says that you are not entitled to a recovery because you have, quote unquote, brought about your own downfall. How would that apply in a slip and fall case? Typically, the store would argue that, all right, if there was a dangerous condition that existed on the floor, the customer has to use reasonable care for their own safety. So, and what that means is maintaining a proper lookout. So the store might argue that if there was a dangerous condition on the floor, that the customer should have looked, should have seen it, should not have put their foot in the liquid or whatever the object is. And if the customer did that, then they're partially at fault. And so, as in many cases, and in slip and fall cases as well, the plaintiff is essentially really walking a tightrope to get across to the other side to navigate these legal issues, and they can be challenging in a slip and fall case.